that, I think Mr. Gupta's presence may be required at the end. Please request him to be here at the end when Shyam Diwan concludes his argument.
Yeah. Now, not that we both can't be wrong. Your lordships will be right under our system. But this is what the government of India says on affidavit dated 16th of November 2022. I'm reading paragraph 11. So let's see their stand, let's see my stand. The notification SO 3407E itself, however, did not extinguish the liability of RBI under subsection 1 of section 34 or that of the central government under subsection 1 of section 26. For the cessation of those liabilities, the 2017 Act was enacted by Parliament. So I'm not saying we both can't be wrong on this, but this is our position which supports the private which I'm sorry.
Assuming you are right for a moment.
And pay on this point.
Assuming you are right on this point. In any case, the ordinance has come on 30th.
So we are coming to that. That's what
after 38, in any case, it has ceased to be either having a guarantee or a status of a legal tender.
So
in any case, even by the 2016 notification, there was a period till 31st of December for exchanging it.
Okay, so
what turns on this?
So that's important. So two things turn on it. So first of all, the reason we are making this, emphasizing this submission is for clarity because the lordships are laying down the law. So let's understand it. And now let us see, because I'm going to deal with the Attorney General submissions in a moment. Now take up the Act of 20. So now I'm answering the question.
No, is it your argument that
yes,
even after 30th of December 2016,
yes,
still the guarantee of the Government of India persists to exist?
So we see that, according to me, on a construction, yes, because they themselves say so, up till the extended grace period dates. So I'm coming to that. So now take up the Act, please. It's in my compilation volume 1. Now I'm done with the RBI statute. Now I'm pinpointing and answering your lordship's question. We have seen that the Government of India's affidavit supports me on this limited point that by itself it did not extinguish the guarantee under 26(1) or 34, which is why the ordinance was necessary. Now, sorry.
You are relying on their affidavit dated?
I am not relying on it, but I am referring to it.
Referring to it.
Yes, yes. It's 2016. It's filed on 16th November 2022. It's an affidavit filed on behalf of the Union of India in Vivek Narayan Sharma, and it's paragraph 11, first 3 lines. So yes.
One question to you.
Yeah.
According to you, on what date it ceases to have what is that legal guarantee? Legal guarantee.
In
what date?
31st December 2016. Because coming to that.
That is the expiry date in that notification.
No, not in the notification. So now let me just answer that.
According to you.
Yes. So let me just say. I'll answer that straight in 2 sentences. And first sentence, the notification did not extinguish liability either under 26(1) or 34. First sentence. Second sentence, that happened by virtue of the 2016 Ordinance /2017 Act, Section 3. So this is a 2-sentence answer. Let me just repeat that. The notification by itself of 8th of November did not touch upon 26(1). It did not extinguish liability under 34. It did not. The guarantee and the liability remained. But there was an subsequent act, not intervening, subsequent act in the form of this ordinance, which comes into force on 30th, which is issued on or promulgated on the 30th of December 2016, takes effect and gives 1 day's time till 31st December, and therefore on and after 1st of January, no guarantee under 26(1) and no liability. Now for that, let us see this.
being a contract lawyer and ending up with a constitutional lawyer. So if you start as a constitutional lawyer, you don't like contract. If you start as a contract lawyer, you don't like constitution.
No, there's one third sentence which I have to also supply because to complete the answer. On 8th of November 2016, it forthwith ceased to be legal tender. That I should have mentioned.
What is the, sorry, please repeat.
Sorry. The effect of the notification was that the specified notes immediately ceased to be legal tender. So under 26(1), the seizure to be legal tender was immediate and instantaneous the moment that statutory notification was issued. However, the cessation of liabilities did not happen instantly, but happened eventually on the 31st of December 2016, not because of the notification, but because of the ordinance. So I come to, I hope I made myself clear. I'm attempting to answer Justice Nazir's question. What happened on 8th November? By virtue of the notification, legal tender, we're going back to 26(1). Every banknote shall be legal tender. That stopped. It stopped being legal tender under 26(1) immediately.
For my question,
Yes, sir.
one answer came from the system. That is, if there was automatic extinguishment of guarantee, where is the necessity for an act was the answer to my question which came from the bench. But then another question is, in 1946, Ordinance 3 of 1946, there was the first demonetization which happened through statute. So once a statute has come, there is no necessity for a second action, correct?
It depends on the terms of the statute. I fully agree with you.
Section 26 capital A was introduced by an act of 62 of 1956, reiterating that why is there a second statute?
26(a).
Yes, 26 capital A.
Notwithstanding anything.
Therefore,
26,
you
no,
can't
no.
ignore the fundamental concept of this liability of the guarantor being coextensive with that of the principal debtor. Cannot be, that you can't go against the most fundamental principle. You have other arguments.
Let me suggest,
Sir,
sorry.
Let me intervene. I didn't mean what my learned senior brother meant. The reason why 26A came was the earlier demonetization were by an act of parliament. That is why they say, notwithstanding anything contained in section 26, no bank note, etc. came. And in the earlier two demonetizations, the extinguishment of liability was in the Parliamentary Act itself, unlike here where it is by an executive order. Therefore, 26A, by way of precaution, it was added.
Then where is the second act? Why should there be a second act?
I'll tell you, Lordship.
Here,
Let me just explain it simply.
Not in the executive
Yeah,
order.
so let me explain it as even more simply if I can. First, I ask myself, can Parliament, in exercise of its plenary jurisdiction as a theoretical issue, pass a law extinguishing both legal tender as well as central government guarantee? Only parliamentary statute or ordinance. My answer is yes, it can do that. All right, subject to whatever constitutional safeguards, etc. there are.
No problem.
Correct. So first, Parliament can do that. One. Number two, employing the expression which your lordships have used in internet mobile and which the Attorney General quotes, RBI is a creature created with a mandate to get liberated even from its creator. Now what that meant is, sorry.
Correct. Therefore, the judgment should get liberated from the creator now.
Yes. So whatever. So you have plenary power, which we all agree, at least tentatively, that Parliament can certainly do it. The question is, can the executive do it? The answer is yes. The executive can do it following the discipline and rigor under 26. That's the second level. Then we come to a third level. What can the executive do? Sorry. The executive override Parliament through notification. Yes.
Even under the 1978 Act,
Yeah.
the provision that was made that on an expiry from such and such date, all high denomination banknotes shall, notwithstanding anything contained in section 26 of the Reserve Bank of India, so and so,
Correct.
cease to be a legal tender.
Yeah.
There is no specific provision as has been made under the now 1917 Act. So if your argument is to be accepted, then those notes of 10,000, 5,000 denomination still exist. And if somebody has, then the government is guaranteed to pay it.
Yes, sir, yes.
If the argument is to accept it, it will have to stay to that.
No, maybe we'll see that. I'll examine that and I'll come back to your lordships on that. But now, fortunately for me, not only does the union government say it on affidavit, but
in any case, what turns on it?
so we'll come to that in a bit. We'll come to that. But now let us see what the ordinance says. Let's see what the ordinance says now. So I am requesting your lordships now to take the ordinance. Please, that's at page 38 of my compilation 1. We are looking at the ordinance, not the act. The act is in same terms, but the ordinance came first. Parts. Page 38, please. Parts of the preamble. See the second recital. What is the ordinance to do? An ordinance to provide for the cessation of liabilities on the specified banknotes and for matters connected therewith. So this is their view. They may be wrong, of course, but this is the target, the object, to seize the liabilities on the specified banknote. That's the objective. Now see the last recital on the same page, page 38. And whereas, not it is desirable, whereas it is necessary to have clarity and finality to the liabilities of the Reserve Bank of India and the central government arising from such banknotes which have ceased to be legal tender on the basis of the said notifications. So it's very, very, very clear. There's a reference to the notifications of 8th of November 2016 in the second recital. Therefore, you have this particular ordinance. Now look at section 3 or ordinance clause 3. Yes, your lordship also had a question to me with regard to when it shall come into force. So please just see that the ordinance comes into force on 31st December 2016. Much turns on this, and appointed date means 31st day of December 2016. Because please recall the Prime Minister's words. The Prime Minister's words, your lordship recall, which I read to you. Your money will remain yours. You need have no worry on this point, first statement. And the second statement he made was that, look, at Reserve Bank of India counters, even after 31st of December, you will still have your chance to change your money. So, and then you have that definition of grace period specified by the central government by notification. Now, please focus on 3. Look at the marginal note. Specified banknotes to cease to be liability of Reserve Bank or central government, both. Now, let us see. On and from the appointed day, notwithstanding anything contained in the RBI Act or any other law for the time being in force, the specified banknotes which have ceased to be legal tender. First concept, ceased to be legal tender. in view of the notification of the government in the Ministry of Finance 8 November 2016 issued under subsection 2 of 26 of the Reserve Bank of India Act, shall cease to be liabilities of the Reserve Bank under 34 and shall cease to have the guarantee of the central government under subsection 1 of section 26 of the Act. So this is the extinguishment.
And this is with
Yeah.
effect from 31st of December.
Absolutely. So till 31st of December, till 31st December, their liability remained. So two, I'm answering the question. Their liability remained in, the concept is twofold. One, as your lordship correctly puts, 31st December. But then you recall there's also a grace period concept in the statute itself. So that liability and the guarantee may extend to the grace period in notified situations. But the important point is the one which you make, namely that on and from 31st of December, what happens because of this statute? Has it ceased to be legal tender because of this statute? No, that has already happened on the 8th of November. What has happened by this is not executive. This is statutory in the sense legislative, legislative and something further and in addition. What I'm trying to emphasize is this is not the same thing which has already happened. 26(2) notification, which is the procedure and the mechanics, and which they say was followed, etc. We say not followed. That's a separate argument. That extinguished the legal tender. You couldn't accept it. I couldn't go. Your lordships asked me that, look, could you pay a staff member or an employee after this date in these currency notes? The answer was no. Rightly said by the Reserve Bank, because it had ceased to be legal tender. But the liability remained right until 31st of December, and for good reason. There's another answer to the question your lordship put to me.
The liability of both RBI and the government
Remained
therefore
till 31st December.
therefore they coexisted. You understand?
Of
That is
course.
why
Yes.
that is why it did not, they were not
There is no severance.
separate bogies. There was no severance of, see, the liability of, that is why from the beginning we have been saying, see, look at this. Their currencies, their banknote ceasing to be a legal tender is
Yes.
item number one.
Correct.
RBI's liability getting wiped out from the balance sheet is another one.
But it's a liability. You're right.
Therefore, the liability of both RBI and the government as a guarantor got wiped out together, not separately.
Yeah, that's the scheme.
No, you started off with saying that
No. Let me just tell your lordships in the plainest terms.
Why learned brother?
Yeah.
On the basis of contract that said that once the promisers,
It is
promisers cease
So
to be
let me
the
answer it.
character.
Let me answer it directly in terms of contract. Contract law, one, is subject to statutory law in certain situations. One. Two, these are separate liabilities and guarantees. One, government, the other, as far as the RBI is concerned. That's the second point. Parliament could very well choose to extinguish both together. But that does not mean that they, in an appropriate or other case, may choose to do it differently or distinctly. Please don't rob Parliament of that power. Please. So the answer to the question is
That
why,
question is for consideration as to whether it can be done separately or not.
that in an appropriate case, here that doesn't trouble us.
We can't decide on the basis of hypothetical situation.
You should ought not. I said that your lordship certainly ought not. That they have done it here. What I am suggesting is that they have done it here and they've extinguished.
I'm sorry, I'm repeating again and again.
Yeah.
Even if you accept your argument for a sake,
Yeah.
that the guarantee and even suppose even the promise
Yes.
exists till 30th of December.
Yes.
And once an ordinance comes into effect,
Yes.
what is the then?
What is
I'm not saying, but see, there are two, sorry.
Please develop the further argument.
So I'll state the point straight away because I've mentioned that in the answer. I am not for a moment saying let me answer the question. The answer is twofold, and then but please allow me to complete the argument. The answer is one. This came in on the 30th of December with a hard stop on the 31st of December with a grace period. So I'm going to request the court to interpret the grace period in a manner which is just and reasonable. Because that's in section 4. My submission is going to be having regard to the fact that the liability was extinguished the assurance of the Prime Minister, it would be completely unreasonable, or to borrow the expression, manifestly arbitrary and unjust, to have just 24 hours to change. Because the entire regime until then, as understood with the grace period, is that this is going to extend. This is one part of the argument. The second part of the argument, and I'm going to pick up the Attorney General's note right away, I am going to respectfully submit there ought to be clarity as laid down by this court. And that's the second part of the argument, because I have to deal with the arguments which were made in writing. So now I have mentioned to the court now let me just sum up on this part, then I'll come to section 4. What section 3 does is, therefore, it only does one thing or two things: extinguishes central government guarantee, extinguishes RBI liability, and therefore builds on what has already happened. So what does it not do? And that's very important. It does not validate anything which has happened earlier. One, there is no question of merger. Number two, and that's my respectful submission. Now please pick up, because before I go to section 4, please pick up the Attorney General's submission. Only 2 paragraphs, and those are para 2.5.3 and 2.5.4. This is what I am addressing now in all this submission. Please go to 2.5.3. This is the additional submissions of the Attorney General. If it's the same copy that I have, it should be on page 11. Only 2 paras I'm going to read. It's a para beginning nevertheless.
Point
5.3. It's titled Additional Submissions.
page 11.
Yes, and it's handed in on the 5th of December.
This was on the main argument were advanced on this basis.
Yeah. Your Lordships have it? Correct. So now let's read it. Nevertheless, the submissions advanced by the petitioners carry no weight, insofar as they fail to appreciate that even in the present case, the government exercise of powers under 26(2) has been incorporated by reference. Please mark that. First legal concept, incorporated by reference into the specified Banknote Cessation of Liabilities Act 2017, and therefore the same was effectively been validated by an act of parliament as well. So this is the second legal concept in this one sentence, 2.5.3. Incorporated by reference, validated into an act of parliament. 2.5.4. The notification of 8th November 2016 has been affirmatively referred to in section 3. By such affirmation, Parliament can be said to have taken into account the notification and its implementation scheme. As a result, since the notification has, now this is the third concept, merged in the parliamentary law, it has ceased to exist independent of legal instrument. It has ceased to exist as an independent legal instrument. It must be taken that regardless of any issue relating to the exercise of power under section 26(2), the decision to withdraw existing series of certain denominations from legal tender must be treated as a parliamentary plenary declaration. So there are 5 concepts, maybe there are more. Incorporation by reference, validation, merger, cease to exist. The notification itself has ceased to exist as a legal instrument, and parliamentary plenary declaration. Now I am going to respectfully submit very quickly that each one of these is incorrect in my respectful submission. First of all, I would respectfully submit that this is muddling up all sorts of legal concepts which can't be muddled up in these 2 sentences. So let me specify. First concept, incorporation by reference. Incorporation by reference is a concept, is a legal concept which this court regularly applies, where a statute doesn't want to repeat all the statutory provisions again and again because they are already contained in another statute, and therefore it makes a reference to that particular statute. And then there's a whole body of case law as to whether amendments to that other statute get incorporated here or not. That is the concept of incorporation by reference. Here there is no incorporation by reference. There is certainly a reference to the other notification which was in the executive realm. This ordinance is dealing with legislative power, completely separate and distinct. Second concept, validation. Validation arises when something is declared ultra vires. It may be ultra vires for a variety of reasons. There's no concept, no court had said that this is ultra vires. No one at that point of time requiring validation. In any case, 26(2) is an executive power, doesn't confer any authority on parliament. There's no question of validation. So that's my second answer. Third concept is merger, merged into parliamentary law. My respectful submission is this is two distinct things. One was an administrative action under 26(2), another was an extinguishment of liability under 26(1) and 34. There's no question of merger. The fourth point is ceased in law, it has ceased to exist. I think this is, well, I don't think this is even stateable, frankly, except that the Attorney General has stated it. It has its life. It had complete impact across the country, and it had full force of law, subject to, of course, what your lordships now hold. It had the full force of law, and it operated immediately on being issued on the 8th of November 2016 until the 31st of December, when there was a period, but it ceased to have any legal tender basis. So this to say that it merged into a statute is, again, in my respectful submission, ceased to be an independent. It continues as a legal independent instrument. The bullet has been fired. It has, in the form of the notification, it has carried its course and it has done what it has done. It doesn't cease to it. It doesn't have any impact or effect later on because it was self-contained at a certain level. But legal tender immediately stopped. And finally, it must be treated as a plenary parliamentary declaration. I don't think any plenary parliamentary declaration is made or even attempted to be made by this bill. So that's my respectful submission. Now we come to section 4. Now, before we come to section 4 of the ordinance,
How can it be given that by a plenary parliamentary declaration?
yeah, there is none.
No, a specific statement is made that from 31st of December so and so,
Yeah,
all these specific bank notes shall cease to exist.
yeah,
And the guarantee and the promise
absolutely right.
shall cease to exist.
So just see that these it's two different things, my lords.
It is
Where's the question of merger cease to exist? These are, what the ordinance does is it extinguishes. Sorry.
What has been done
Yeah.
under the notification of November,
Right.
what was provided was that
Legal tender.
it shall cease to effect from legal tender.
Correct.
And it granted a window till
Right.
30th of December to exchange the notes.
What does that mean? The guarantee was still there.
Guarantee was there.
Yes. Why was it there? Because that's why you could exchange notes.
And therefore, because they,
So-
you see the fourth,
No, but may I just, sorry, with your permission.
you see the fourth whereas.
Yes.
And whereas it is necessary to have clarity and finality.
Finality, yes.
So the parliament might have thought that there might be some ingenious arguments, and therefore to take care of that,
No, this actually,
a specific ordinance.
yeah. So I'm actually obliged to your lordship's question because I think it answers the earlier issue which I did.
If
Sorry.
your argument is to be accepted,
Yes.
it will have so much ramifications because under the 1778 Act, there is no
No.
such declaration under section 26 and 34. And those 10,000 notes will still have to be honored and by the government.
Sorry. So let me just, Manoj, I think part of it is answered, part of it is answered. The fact that the guarantee and the liability continue on and after 8th of November 2016 is now I'm supplying two more reasons. The first reason is it's clear from the fact that they exchanged notes. That's reason one. And the second is,
And the notification itself provided.
yeah, of course, because of a guarantee which was extant and outstanding, and because there was a liability which was extant and outstanding. That's the reason. But there's another reason. The second reason is that you could not have an executive direction which invalidates a statutory obligation under 26(1) and 34. That's the elementary proposition which we are canvassing. Of course, there may be some subtle argument under contract law, but the legislative argument is, or the administrative law argument is, or the constitutional architecture argument is that you cannot have executive action nullifying a statute under the very statute under which the executive action is issued.
I have been repeatedly saying that even if you accept your argument,
Yes.
that the November notification,
Correct. So now now I'm only on that.
Under the said notification also the deadline
Yes.
was the same, and under the ordinance also the
All right. So now let's answer that. Now we are focusing on that. So first, your lordship, grace period.
Are you trying to say?
Yes, sorry.
Are you trying to say that it was because of the guarantee which continued
Yes.
that there was provision made for exchange of notes
Absolutely.
and the banks
Absolutely.
see, they ultimately, because the banks accepted the notes which ceased to be legal tender and they gave valid notes, the new notes. Otherwise, the banks had no duty to exchange the notes which the central government had said had ceased to be legal tender.
That is absolutely my point. My point is that the guarantee and the liability continue.
The provision for exchange is a continuation of the guarantee.
Absolutely.
The guarantee is extinguished. You may say that.
No,
That is my very submission. Manoj, let's be clear. Manoj.
provision for exchange.
Yes, sir.
In the notification.
The provision for exchange is a continuation of the primary liability itself, not
Yes.
just the extent of the guarantee.
Government guarantee,
No, the liability, the RBI itself continues.
34.
Therefore, the notification did not extinguish the liability. 8/11/2016.
It could not.
Because they said the window is open for exchange. Unless, if suppose the liability is wiped out on 8/11, they can't re-exchange the notes. Therefore, that is the reason why the liability continued. Legal tender also only ceased to exist.
Correct, correct. The liability, otherwise, they would not have.
Not just the guarantee, not just the guarantee, but the liability.
The bank.
Not just the guarantee.
I am in 100% agreement with the observation made that on and after 8 November, according to me, the liability continued, the guarantee also continued, both continued. Eventually, as Justice Gavai has correctly pointed out, extinguished on 31st December 2016, subject to judicial review by this court. But that is the scheme which was followed. So that is why, because I'm obliged for that question, the reason why they were obliged, apart from being in terms of the notification itself, there was an outstanding statutory notification. Your Lordships have noticed my point. An executive that sort of the tail card. The power coupled with duty. Now, for that, let us go to page 44. Because what I'll just indicate what has happened here. I'm now responding. I thought it was fairly insensitive, but I mean, we can't use stronger expressions than that to describe the attitude of both the Reserve Bank of India and the Union of India. These are genuine cases. What are you going to do about them? Now, please see 44 first. Go to page 44. Now, this is what they do on 30th December 2016. Now, I am relying on a part of this notification. And I am going to show your Lordships 2-3 ways out. If we are right. Please go, stay same compilation 1. Please go directly to 44. Now, just see the first part. In exercise of powers conferred under clause B of subsection 1 of section 2, read with clause 1 of subsection 1 of section 4 of the specified notes, that's ordinance, the central government hereby specifies in respect of citizens of India referred to in clause so and so of the set. So this is issued by the Ministry of Finance. Please note that this is not an RBI notification. It's a Ministry of Finance, Government of India notification. Now see this, I am quite happy with A, who is a resident of India. So they are specifying the grace period, who is a resident of India for the period ending 31st day of March 2017. And B, who is not a resident of India. This is what covers me. A period of 30th day of June 2017 as the grace period for the purpose of the said ordinance. Now, so far, I am in a very happy situation because it's still the 30th of June 2017. I'm in a KYC account. I've got the money, this, that, and the other. There's no problem at all. All right. This is one aspect. Now they have a proviso. So there are two ways of reading this proviso. First, let me read it and then make the submission. Provided that the amount in the specified notes rendered does not exceed the amount specified under Regulation 3 or Regulation 8 of Reserve Bank of the FEMA dated 29 December 2015, made under provisions of the Foreign Exchange Management Act and the conditions specified therein are complied with. Correct? This is the proviso. Now, first submission. This proviso can only apply to people who during that period were out of the country. That's one. I am not there. I was sorry, it can only be applied, my mistake. It can only apply to people who carried currency out of the country, and who were away. The proviso, well, please see, who is resident in India for a period ending 31st day of 27 and who's not resident 30th June 2017. So I am saying let us go by this part of it. It will be enough. It gives me relief. There's no problem because I landed well before 30th of June 2017. In February itself, I tendered my money in one case where, so there is no problem. And insofar as for people who are out of India, correct? So there's no problem. Now, what is the effect of the proviso? The proviso restricts it to someone who carried an amount abroad and brought it back. Now, I was not in that category. My money was lying in India. So therefore, the proviso has no application. So this is one way your lordships can grant relief to citizens who had left the money in India and were away from the country during that period. What is the method? The proviso does not apply to people who had left the money in India. That will give a huge amount of relief to people such as myself, people such as who Mr. Rao was representing, etc. Sorry.
What would be the mechanism?
No, it's,
No, to find out that those non-resident Indians had genuinely kept the money when they were traveling out.
so they have to be satisfied. That will be on a case-to-case basis.
The notification are for two classes.
Yes.
Insofar as the persons who are residents in India, there is no such restriction.
There is.
No. There is subsequently it is clarified.
No, we'll come to that. Manoj, your lordship is right. There is that clarification which I'll deal with separately.
For resident in India,
Yes.
there is no limit.
Yes.
There is no requirement for declaration.
Correct.
Then the proviso is applicable only those persons who are NRIs.
Right. So how? So if what about an NRI who has left it in India? Well, I mean, that's like, can you imagine what a huge group of people that is?
Well, even NRIs don't have a
NRI,
restriction.
sorry?
Even NRIs don't have a restriction up to 31st of December. The rest,
We are talking about grace period.
Then Mr. Yuval said asking them to return before 31st of December.
is unreasonable, manifestly arbitrary. and
Yes, it is manifest or extraordinarily cold-hearted.
Where,
Maybe the tickets would have costed them more than 1.5 lakh.
Millard, what was he doing for these 2 months when the notification said that he will get this opportunity only till 30th? Can he say that he can
It's an astonishing submission.
Can he say that he?
It is the most callous submission on behalf of RBI.
Merely use
make
the word
submissions
callous
like
will
this.
not help.
Atmosphere outside is quite pleasant.
And polluted.
So according to him,
Yes.
this has to be linked with the right to life. Right to
Millard,
he has the right to live with dignity, and
Yes.
therefore he is not expected to come back for this party 1.6 lakhs when the tickets itself would have costed him more than that.
Millard,
No, it's much more. Actually, it's much more than that. I will explain that to you.
he has come back in February. He could have come back in November. Millard, the question is whether no opportunity was given to him or not.
We have noted your argument yesterday that till 31st of December,
Yes,
everybody had opportunity to do away with everything.
everything.
Now, let me just deal with this argument right away. This is a wrong submission on facts which is made because until the 30th of, so please note this now.
Till 30th.
Until 30th of December, the assurance given by the Reserve Bank of India and the Prime Minister of India, no less, was that you will have an opportunity even past that date. And I'm going to point that out.
Millard,
And
we
it's
have
only on 30th of December they
argument
said
has
there's
to
a
be-
hard stop on 31st December. Is that reasonable?
We permit you to address because
Millard, this is a rejoinder. Millard, it is very difficult for me, Millard, to collect all this material and give it to your lordship today. So I'm, Millard, the ones which are obviously incorrect, Millard, please permit me to point out. The notification said that exchange will be permitted only up to 30th December. So this argument that Reserve Bank said that he will get after 30th December, that the Prime Minister said that he will get after 30th of December, all this is, Millard, irrelevant. The notification, which is the law, said 30th December. He knew that.
When did that notification come?
Millard, 8th of November, this is the first notification.
Oh, you're referring to.
First notification.
No, there was another notification of 30th of December.
No, the
Yes, I'm coming to that.
I'm sorry, Millard,
that is
30th,
what you are reading.
30th December, Millard, is grace period notification.
Grace period.
But Millard, there is a primary notification which gave them the right to exchange whatever they wanted to. And Millard, the answer to your lordship's question as to why would banks honor after Millard 8th of November is because the notification said they will honor. Millard, the notification said so. They will honor under these circumstances. from the beginning.
That is
So it's the
because
law.
Central government has guaranteed the currency.
Milord, it doesn't matter whether they
Liability.
Milord, it doesn't matter whether there is a liability, it doesn't matter whether there's a guarantee. The notification says,
Gupta, since some new points have come, we'll
Yes.
get guarantee.
all right, very well.
Now let's just get rid of this point because I mean, I find it in plain English, but anyway, go to page 27. Let's just answer this point. Just go to page 27. Paras 9 and 10 first.
So already read it to us.
I know, but then it's being said over here that on 8th of November. Now look at his statute. Look at the statutory notification issued by the ministry. Please see this clause 9. Why is the statement being made contrary to the statutory notification on page 34? Look at clause 9 on page 34. Any person who is unable to exchange and deposit the specified banknotes in their bank accounts on or before the 30th of December shall be given an opportunity to do so at specified offices of the Reserve Bank of India or such other facility until a later date as will be specified by it. So this is the government of India making an assurance to all people. And I'm told just now that on the 30th of December, I should have bought a ticket which brought me back into India by the 31st of December.
How did you read?
I mean, this is an astonishing submission by the Reserve Bank of India, contrary to the Ministry of Finance statutory notification.
How do you?
So the whole scheme is that if the Prime Minister says it, the statutory notification says, we are not going to take away your money after 30th of December either. This is what even after 31st of December, till 30th December was given time. But this is a statutory notification on the basis of the Prime Minister's statement, and you suddenly change the goalposts on the 30th of December, and you say that now we are not going to do it even if you're abroad. What was I to think when I was overseas? Apart from the points which your Lordship correctly put to me, what I was to think was that, look, this is a reasonable government. I have a constitutional right to property. I have my money which has been withdrawn and which is lying at my home. I'm not required to rush back and spend whatever amounts which are there, provided I get a ticket. I will come back. I came back in February. Now please go to the statement, therefore. So one part which I am suggesting now, I am suggesting to the court that this proviso at page 44 applies only to currency gone out if there is a case made out of a person who has left the currency in India. It ought to be accepted because the proviso has no application. That's my first submission. So please clarify that. That will give a lot of relief to a lot of people. The proviso obviously applies only to people who go out of the country and who come back. That's one reasonable interpretation which can be given. I would respectfully submit. I would commend it to the court. The second reasonable interpretation is, now please go to bottom of page 47. These are the RBI guidelines. Where do they get this from is the question I ask myself. For non-resident Indians. Now, please see. So there is paragraph 3.4 at the bottom of page 46. Your Lordship, see second last line on 46 is 3.4. Please note that my relief which I sought was strike down this insofar as it applies to me. Now in 3.4, the terms are specified, and for non-resident Indians, tender should be submitted along with the tender form, Roman 2, Roman 3, tenders will be restricted to a maximum of 25,000 per individual depending on whose notes were taken out of India. So again, my submission is, all these requirements of certificate of Indian customs on ascertaining that the tenderer was abroad and had a KYC, please interpret this particular set of directions given by RBI as confined to people who took currency abroad, but it is silent on people who left currency here. And I think, in my respectful submission, I don't know, I suppose jet-setting lawyers can go up and down the country and buy a ticket immediately and come back, etc. But I think the government of India adopted a very reasonable stand initially when they kept it open because they were respectful of rights. And to answer Justice Gavai's question, I think the presumption has to be that citizens who come and who have genuine cases, if they are able to explain it on the strength of an affidavit, it's bona fide and on the basis of passports, etc., and there is no history of them being a history cheater or something, should be presumed not to be a terrorist, someone engaging in trafficking or counterfeiting. I mean, these are amounts which are a huge amount of for the individual himself or herself, and to be just so. Therefore, I come to the point that this exclusion in the RBI. So that's the next route which your lordship can follow. Clarify the notification of 30th of December. Another route can be clarify that this RBI notification applies only to situations where currency was taken out and brought in. For those who say that the money remained over here, they must be given an opportunity. Otherwise, it means that there's a huge class of people. Now I'm in terms of the notification. It's a huge class of people unfairly excluded from the process. And it is no answer to say that you had for 50 days to come back to India. It's no answer to say. This is a very patronizing attitude on the part of the RBI that, look, I will issue a notice. And how could I, the submission made was hope of extension. There was no hope of extension. My rights were not founded on a hope of extension. They were founded on the basis that the Prime Minister and the statutory notification issued by the Ministry of Finance on the 8th of November both said that there will be avenues available to you even after 30th of December. And it came through. So why exclude me is the question I ask myself. Such exclusion is completely heartless and completely arbitrary is my respectful submission. Now please go to section 4. Now I'll wind up on section 4 and then a few other small points. Section 4 at page 40, clause 4 of the order, page 40. So does your duty to cover, your duty to have an appropriate notification, does it not extend to situations like us? That's the question. Power coupled with duty, 4.1. Notwithstanding anything contained in section 3, the following persons holding specified banknotes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank or in such other manner as may be specified by it, namely, please go to Roman 2, such class of persons and for such reasons as may be specified by notification by the central government. So my first submission is excluding a category of NRIs who had money in India is arbitrary in our respectful submission. It is so manifestly arbitrary that it is under-inclusive, going under the traditional classification test. NRIs form a single class. Some carried the money out, some left the money here. Both have to be treated similarly. You cannot create an artificial barrier or an artificial subclass and extend the grace period only to people who carried money abroad and didn't and declared it in the customs, etc. when they came back. So it is under-inclusive, is my respectful submission under the classical test. It's manifestly arbitrary to exclude us as a whole category. Apart from the other categories mentioned by Justice Gawai, there's so many people who may be medically unable. There is another person over here, for example, whom Mr. Prashant Bhushan represented, Sarla Srivastava. Her husband had died in 2016. And in 2017, January or February, what was it? January, when she was cleaning up some trunk, or what is the correct expression? Steel trunk. She was cleaning up a steel trunk. There was money which was discovered, 1,79,000. It's a lot of money for her. Her husband had died. Now, this is in January. And she wrote to the Prime Minister and said, please help me out, which was referred to here and there. And then now she's in court. And this, therefore, is a very important. So that exclusion for genuine and hard cases, I would respectfully submit, puts an even higher duty on the government to be sensitive to such cases and to create an appropriate subsection. So my submission is, central government is wanting in its duty. The second submission is that subsection 2 is in any case a standalone provision. Your lordships have said that we prima facie, I mean at the opening, not after, before hearing them, felt that look, this is something power coupled with duty which even the RBI can exercise, but RBI has also acted in a manner which is incorrect. Now I'm done with this section 4 part also. Now 2-3 small points remain. The first is on judicial review. And I want, so I'll just sum it up. There appears to us to be a yawning gap of persons not covered, a huge gap. I've indicated 2 or 3 situations. There ought to be at least some broad categories to capture genuine cases such as this. So one part of the argument is yawning gap. The second part of the argument is, in any case, grace period has been extended to all NRIs till 30th June. Why deny it to me? Just because I kept my money here. That's the second broad argument. Now I'm on judicial review. Judicial review, your lordships know, have been held to be part of our basic structure of our constitution. There's a whole bunch of series of Supreme Court constitution bench judgments on this point. Now, what's the issue over here? Judicial review is being disabled at 2 levels, and I would respectfully submit, you please, your lordships will have the time to reflect on it and to decide what the correct course of action is. Just take a hypothetical situation. I'm not saying this is the situation here. Supposing under 26(2), the government had handed over minutes and agenda notes and notice and recommendation. And in this hypothetical situation, supposing all 4 of them were blank sheets of paper, what would the court say? The court, does it have the question I'm asking myself is, the part of judicial review and your lordship's oversight, judicial review oversight, limited as it is, surely extends to an informed decision on parts like this. And an informed decision can be arrived at on an issue like this in exercise of your power of judicial review. So the request is, don't diminish the court by allowing them to keep these documents, which are not some high security documents. They are administrative documents. They must be they ought to be disclosed. They ought to be perused by the court. Why? Because it reduces and diminishes the power of judicial review. So please consider that facet as well. And I would be greatly obliged. I think the part on guardrails and to lay down defining parameters is an aspect which survives apart from individual cases like mine, where there may be 1,62,000. I believe it's an imperative. We are way past this stage where you can have some diktat issued by some ruler or something like that and say that what I say is final. No, it is subject to being reasonable, fair and just, whether it is statutory or otherwise under our constitutional scheme. So how is this power of judicial review to be exercised unless these basic documents are made available to the court? So I would respectfully implore the court that please also, as far as guardrails are concerned, and what are the parameters, whatever appropriate expression your lordship would like to use, please use it. The other element is on the question of academic. Your lordship correctly said that your lordship yesterday itself, in the course of Mr. Chidambaram's submission, said that the Bombay case is surely an answer to a situation like that. But there's a useful passage in, the Attorney General referred to a New York Court of Appeals judgment of 25th of September 1877. One of the judgments cited was a New York Court of Appeals, 25th September 1877, in the People versus Amos Clark. And it had a very good line. And I think the reason why the Attorney General probably submitted this was to show the importance of this principle, which was laid down in this 1877 judgment, and how it ought to commend itself to the court. The test laid down by the New York Court of Appeals was, can effectual judgment be rendered? And I believe effectual judgment can be rendered on the overall parameters and on individual cases such as those which have come for the court. So this issue is far from academic. My final point, so it's not moot as has been suggested. Now my final point is that we have submitted written submissions, which your lordships may take note of. It's a written submission on behalf of the applicant. The title has Malvinder Singh in it. It's a fairly detailed set of documents. These were prepared at a certain level before the arguments concluded to give our overall. But your lordships have been very kind and indulgent, and I'm very grateful for a very patient hearing. Yeah, you may consider, therefore, there's one aspect, sorry. There's one last aspect which you may consider. And it's really in the exercise of this court's power. It has nothing to do with the state. I'm now not on what their conduct is or what their actions are. I'm on this court. What did this court do? Your lordship recalls that in the opening I pointed out Justice Kehar's bench had given them a notice that, look, what are you planning to do under Section 4.2? Your lordships also recall the consolidating order which blocked everything from other courts. Now, let's pause here for a moment. On an issue like this, you might have certain issues where you block access to other courts, which are few and far between. But I think we will all agree that as far as value, currency, your property being taken away without authority of law, etc., all these are aspects which affect each across the country. Now just consider, when the court blocks 226 remedy, which we have all grown up and we all know is an inexpensive remedy available locally. Locally in the sense it's available in your state, right there at the state capital or at the seat of the High Court or the benches of the High Court. Now when you're blocking it, I asked myself, and this is what arises here, effectively what is happening is that only people who can do two things, who have the wherewithal to contact a lawyer who's willing to do it pro bono in Delhi and in the Supreme Court. That's a hard ask. It's a hard ask for citizens, most of us. I was asking myself sometimes that, look, can I find a lawyer despite being in the profession in most parts of the country? I can't in a short while do that. And someone who will do my case, with reasonable competence and free of charge may be very difficult. So I am suggesting to the court that yes, I am primarily concerned with Mr. Malvinder Singh, and Mr. Bhushan has appeared also for Sarla Srivastava, and your lordships may peruse the facts. But having nothing to do with the other side, but having to do with your lordship's own order, having blocked access in all these courts across the country, would it not be desirable for this court at this stage, if you agree with any part of our submissions, to direct that a scheme which is more general in nature than just for me? I'm not saying that they are obliged to do it, but because your lordships blocked everyone from going, how many have come forward? Very few. Isn't it now a corresponding duty ex debito justitiae, if you agree with our submissions or any part of them, that if relief is to be given, it ought not to be only to Malvinder Singh and X or Y or Z, but it may be for a time frame, but more generally, not because the law requires it, but because your lordship's order blocking access elsewhere perhaps requires it. I'm very grateful. Thank you.
Yes, where is the party in person? Party in person. Madam, you wanted to say something?
Yes, Your Lordship, just.
Be brief, huh?
Yes, sir.
But it's a rejoinder.
I know, Your Lordship, I'm just saying 2-3 points, that's all, Your Lordship. First of all, I'm appearing on behalf of facts, writings, Your Lordship. Which Your Lordship first primarily said that maybe that matter will be tagged.
This is the other issue.
Wait.
Your Lordship, my first submission is that, first of all, we were not allowed from 9th to 14th because we were we were not individuals, Your Lordship, we were having a society account. We were not allowed to deposit in
Madam,
this.
we are not considering that cases.
Minutes, that's
We
all.
are considering those cases. No?
Just some brief facts only for your notification. Thereafter, Your Lordship, as per RBI instructions, we could not deposit because they were, DCCBs were told not to take our SBNs, Your Lordship. And that is why we could not deposit. So my first submission is, despite our best efforts, we could not deposit the amount. Yes, my learned friend said, told yesterday that we were given opportunity and we could have opened our accounts in some other banks, Your Lordship. We were not allowed to do that. So my submission is, Your Lordship, even if Your Lordship is de-tagging the amount, there are SLP, there are transfer petition and there are IAs also, which has to be taken into consideration, Your Lordship. And there should be a general order.
All right.
My submission is this only.
All right.
Like-
Yes, where is the party in person? You want to?
There is this order of this honorable court in this particular matter only, in which NABARD was directed to go and they have not come. I have submitted a written submission on this issue, Your Honor, in my petition.
My banker denied an opportunity to me to make deposit into my bank.
That you have said, no, already you have said.
Yes.
All right, sir, all right. Next, yes, where is the party in person? Yes, Mr. Sharma, Viplav Sharma.
Lordship, please acknowledge.
Tell us.
My lord,
Be
sir,
brief.
very
It's
brief.
only a rejoinder. You should be very brief.
Yes, Lordship. My lords, the first thing first is, if your Lordship sees, my lords, as of present, the stand of the Union of India is, my lords, is what was done by them in the previous government was constitutional and righteous, and it was done considering the policy benefit for the whole of the welfare of the country. So, my lords, if that be so, my lords, and if that contention of theirs is held, which, my lords, I'll assist your lordship, and my senior colleagues have already assisted your lordship on the parameters of the law and etc. So, therefore, what they did was right, and they have a right to do it again and again, whichever government comes in. Now, the consequences of this, my lords, is that what has happened is in respect of the currency, which is inextricably linked with all the citizens of the country, Malats. So therefore, anything and everything, whatever has been done or possibly would be done after Malats, whatever judgment your lordship will be pleased to Malats deliver, will have a Malats far-reaching consequences in times to come. So therefore, my respectful submission is this, Malats, that the notification which was issued on 8th November, Malats, that was in respect of, if Lordship has heard submissions for so many days, is in respect of 26(2), which Malats provided the central government authority on the basis of the recommendation of RBI to be declare a particular any series of currency of any denomination to be no longer a legal tender. Now, Malats, my respectful submission, what I'm trying to draw a little distinction is the whole issue of currency and the nature of denomination of the currency is distinct and different. With my respectful submission, Malats, the currency of the country is a rupee, and it is 1 rupee, and that's why if your lordship would see, it is printed as a coin, and it doesn't have any Malats promissory declaration on the coin. So that is the currency. So the currency did not get demonetized. It was the negotiable instrument which starts from Malats in terms of the RBI Act, which has authority to Malats print the negotiable instrument act in the denominations of various denominations 2, 5, 10, 100, 500, so on and so forth. Now, Malats, therefore, if your lordship, Malats, lordship would be knowing it, but the promise which is made by the Reserve Bank of India is written on the each negotiable. Malats, I'll just take your lordships to. It says, I'm reading out one of the currency which I have, Malats, of a 500 rupee note. Malats, it says, I promise to pay the bearer of the sum of 500 rupees. So it is that rupees which is the currency of the country, which Malats, the Reserve Bank of India doesn't have authority to Malats print or mint. It is only done by the Ministry of Finance, and that's the reason Malats, the Secretary of the Finance has a Malats signature to authorize the minting of that rupee. So what my respectful submission is that demonetization of the rupee did not take place. The negotiable instrument which was printed by the Reserve Bank of India in a particular denomination got declared to be no legal tender. So that would not mean, because it's a statutory, as my colleague Mr. Diwan has argued at length.
Mr. Sharma, all these points have already been argued. What do you want to say in reply? Tell us directly come to the point. All these arguments have already been made, you know.
Yes, Malats. Malats, what I'm
You
saying,
also made this argument.
yes, Malats. Malats, I would
What is there in reply if you...
Lordship, what I'm saying here is there are 3-4 points which I'd like your lordship to consider.
Come to the point. What point you want?
Yes, Malats. As regards to the first, just for the records, Malats, as regards the any series, any denomination point, Malats, that your lordship will find in my petition expressly urged by before your lordships, Malats, and it is in the grounds, Malats. I tell your lordship the grounds is. Lordship, kindly make a note. It's ground H and I at page 33.
All right.
This is specifically urged, though possibly what petition which Chidambaram argued, writ petition number 916, maybe it is not specifically contained, but it is contained in my Malats writ petition specifically. Ground H.
Right.
Then, Malats, I have to say, Malats, that 26(2) has to be tested on the touchstone of the whole scheme of the RBI.
That
Particularly,
is also argued. It was argued at length.
no, my lords.
Don't repeat in reply. Yes.
With this argument, I'm, my lords, trying to tell your lordship a different point. What I'm saying is, if your lordship will kindly consider section 17 of the RBI Act, so it basically provides two facets, that section 17. Now it provides whole of the banking, which involves the money in terms of, my lords, the denomination which is there, and the banking and banking related money transactions. The whole of the section 17 is very elaborative. It talks about how the physical operation of the country will be manned in terms of section 17. And that section 17 also provides that it will be also the duty of the Reserve Bank of India to manage, print the currency, and accordingly 26(1) and 26(2) is also there, and 24 is there, printing and giving us legal status also. So the point I'm trying to make it here is, the minute that notification came in, the whole of the section 17, operation of the whole of the section 17 was rendered otious. That's what I'm trying to suggest, your lordship, because the whole banking got haywire. There are various RBI notification to the effect which I have placed on my record, and there are various other petitioners who have also placed that the whole banking could not take place.
Sharma, what do you want? What do you want to say?
So what I'm saying is that
We are not.
yes, my lords.
What is that you want to convey?
The point I'm trying to make it is that
Sharma, all these questions have already been argued.
No, my lords,
Please close. Please close.
my lords,
You are in rejoinder. Please close.
okay, my lords. And second thing is that on the notification issue, your lordship was very specifically, my lords, called upon the Union of Indian Attorney General on the, my lords, the constitutionality, as because that notification was not issued in the name of the President of India under Article 77. The Attorney General.
All that we have noted. Please proceed.
No, what I'm saying is that AG has not responded to my lord's, your lordship's query.
All right. We will ask the AG. Now you please proceed.
Opportunity is, my lord's, gone. Then my lords may say, then lordship may kindly have my petition for me. Only one ground which I want to urge. Lordship may have page 36 for my petition. Only one submission, and I'll be done with that. But I am saying, my lord, if I may be permitted to read, my lord, a few lines, my lord, for my grounds. What I'm saying, it's ground L, my lords. The demonetization of any currency is completely beyond the scope of Reserve Bank of India Act 34, which is relatable to entry 38, Reserve Bank of India of list 1, given list of the 7th schedule of the Constitution. The demonetization of any currency, which is as reported 86% in circulation in the whole country, by way of declaring the whole of such currency to be ceasing to be a legal tender, is completely outside the domain of the Reserve Bank of India.
Sharma, this was repeatedly argued by many, by almost all learned advocates.
My respectful submission is that the demonetization will take place under the Act of Parliament in terms of Maharash's entry 38, not under in terms of.
It has been argued by everyone, not one, but more than
Many times.
Another.
All right. We will conclude. We will.
May I seek your lordship indulgence to file my 2-3 page written submission?
All right. That we will permit you. We will permit you. All right. We'll just ask Gupta and AG, though after reply there is no provision to hear you, but if you want to say something, you can take 2-3 minutes, and if you have to make, thereafter Gupta can respond, or one of you. Choice is yours.
Mr. Gupta wanted to say something first. I'll try to conclude.
You can.
Milord, this question which has been raised today, Milord, I believe, Milord, it is not really necessary for us to go into it. But since it has been raised, Milord, let me try and answer it. Give me the section. Now, Milord, what has happened is, in 1946 legislation and 1978 legislation, the second stage was not indicated. Milord, presumably, my lord, on the understanding that when legal tender comes to an end, section 34, which says in circulation, also, my lord, comes to an end. On that basis, my lord, it seems to us that the legislature did not provide what is in fact provided in section 3. But, my lord, it is our submission that it is not necessary to have that confusion. That is why this time around, they specifically put it in. They noticed it, and so they specifically, my lord.
Even in 1946,
Yes.
26A has been subsequently introduced.
That's correct. So therefore, my lord, to the extent 26A takes care of it, my lord, no difficulty.
1946.
Yes.
46. 1978 is not taken care of. So, my lord, it is my impression, my lord, that they must have been under the impression that on a correct reading of section 34, once it is withdrawn as legal tender, those guarantees and that liability goes because the notes are no longer in circulation. But in this case, my lord, we don't even need to go there.
No, that is not the way. What happened was, since there was a window provided for exchange, unless the liabilities get reflected in the books of the RBI, they could not have exchanged.
Yes.
Therefore, it continued.
No, no. So I understand, my lord, the submission that this is because there is a liability. Now, it does not necessarily have to be because of that. It can happen simply because the notification says that it will be exchanged. That's an independent obligation.
Though it ceases to have the status of a legal tender,
Yes.
in view of the provisions made in the notification,
Correct.
it has got till 30th of December, it could be exchanged.
It could be exchanged. That is enough. It is not necessary, my lord, to delve on the theoretical basis on which this notification
In any case,
Yes.
in view of the ordinance of 30th of December,
Yes.
it ceases to have any status from 31st of
31st of December, my lord. Note. So therefore, this question, my lord, by itself is not today very important. But, my lord, my learned friend would like to really submit, as far as I have understood, that because it was alive till 30th, therefore there was no sufficient time given. But, my lord, what we are forgetting here is, my lord, that the first notification itself said, do it by 30th.
Yes.
And then it said, there are these subsequent conditions. That's all.
We relies on clause
9. Sub 9.
clause 10.
9, my lord. Page 4.
Sorry, 9.
9, yes.
Clause 10 of the press information.
But, my lord, we have to start with the beginning of paragraph 2, which says that the specified banknotes held by a person other than banking companies may be exchanged at any issue office, etc., for a period up to and including 30th December, subject to following conditions. Now, my lord, what is the normal reaction of a citizen of this country when he faces this? If my lord, 9 is the governing, my lord, clause of this, my lord, paragraph, then please see, it will not stop with NRIs. It will not stop with NRIs who have left money in India and gone away. Every individual, my lord, who thinks he can make out a case that he was unable to deposit the money will come and say that a mandamus has to be given to enforce 9. The deadline will vanish forever for everybody.
Mr. Gupta, repeatedly Honorable Prime Minister's speech was.
My lord, I know, my lord. Now, my lord.
But can you just come to page 26?
Yes.
26, I think all this para 1, 2, 3 have to be read together. Just read that 2, 3 sentences.
I'm sorry,
In
my
the
lord.
compilation of.
Notifications.
Compilation of Mr. Dewan. First compilation.
You can't open it from there. Give me the copy.
You have this.
First compilation containing all the notifications.
Yes. My lord, we've also given that's why, my lord. My lord, your lordship is looking at page 26 of this compilation.
26, last sentence you read, persons holding.
Yes.
Read 2, 3 sentences. Let us read together.
Yes, my lord. I'm just wondering what
Persons holding.
persons holding old notes
Read.
in Malvinder Singh's compilation.
Read.
Persons holding old notes of 500 can deposit these notes in their bank or post office accounts from 10th November till close of banking hours on 30th December
Ah.
2016 without any limit.
Next sentence
Yes.
also, very important.
Thus, you have 50 days to deposit your notes and there is no need to panic.
And
50
next
days.
sentence.
Your money will remain yours. You need not to worry on this point, provided you follow the law.
All have to be read together, perhaps.
Let's suppose you read it together. Suppose we read it all together. What is this assurance said? It has said that if you follow the instructions which have been given to you, then your money will remain safe. You will not lose anything.
50 days time, you own the
50
price.
days time. He has mentioned 50 days there. He has not said that I will give you enough time later on also, not just 50 days. But even if he had, Milord, this is a statutory notification. Now that statutory notification, there is no case which can be made out that there is some kind of a promissory estoppel, that this statutory notification will be extended. What is the legal cause of action here? And Milord, I keep, Milord, asking myself, what would a person normally do? He can come back in February, but he can't come back in November. The cost of the ticket is the same. He has not written, Milord, we have checked. He has not made any, sent any mail during that period.
That you already said, Mr.
Yes, but those are facts. But here, Milord, what I am saying is that the notification itself had provided 30th of December, and what happened was a limited window of opportunity was opened, no doubt, but that opportunity, Milord, this legislation did not want to open it any further. So, Milord, Parliament did not want to open it any further. Not. Yes. To the
central government.
Yes, but even the central government decided not, because, Milord, your Lordship knows that the climate of that time, Milord. There was a feeling, Milord, that some of the provisions were being misused. So if under those circumstances, the legislature and the central government did not want to open a larger window, Milord, there's nothing that can be said about that. Now,
No, but the parliament in its wisdom
yes,
had thought that there may be such class of persons and for such reasons as may be specified,
yes,
that the central government may need to give some kind of a relief.
correct, Milord, but the central government in its wisdom has thought that they won't.
Now, even now, this
Yes.
boy is still there. Even now, central government.
Look at section 6, section 5 for a moment. The person who, contrary to the authority of law, has held those notes is today to be prosecuted if he comes up with notes. Look at section 5.
Then how do you deal with situation where that widow found some money after her husband died?
Lord, it's very difficult, Lord, to deal with every situation like this, Lord. Because if you question is, under that subsection 2,
Yes.
can the court, my lord, now give a mandamus, as my learned friend is asking for, to formulate a scheme? They are saying you formulate a scheme, we or central government, whatever, formulate a scheme to give a very large class of persons, which he says is huge, opportunity to hold on to submit notes even today. Now see section 5.
So this is for the central government to take a
It
call.
doesn't matter, my lord. I'm not, my lord, going on that.
Yes.
My learned friend will deal with it. But please look at section 5. My lord, I'm not going to, my lord, continue this submission. If my learned friend wishes to, my lord, say anything, my lord, he will. Section 5, prohibition on holding, transferring or receiving specified banknotes on and from the appointed date. No person shall knowingly or voluntarily hold, transfer or receive any specified banking notes. And then, my lord, certain exceptions. Then penalty. Whoever knowingly, willfully makes any declaration or statement, etc., which is materially false, etc. And 7, contravention of section 5. Whoever contravenes shall be punishable. Now, my lord, which citizen, my lord, can be encouraged to say today that I have held on to these notes in the hope that the Supreme Court of India will vary the law? It just cannot be. They are under a duty to look at the law and follow its, my lord, dictate. My lord, so therefore, my lord, this.
No, Mr.
Yes.
Gupta, before proceeding.
Yes.
Now, we were talking of this 10th November till the closing of the bank hours on 30th December 2016.
Yes.
Then 50 days to deposit.
Yes.
Then your money will remain yours.
Yes. Yes.
Now, this 50 days to deposit, because I am not clear, I'm just.
Yes.
Was there a limit to deposit the amount,
No.
or any amount what you held could be deposited?
Any amount, you are free to deposit any amount.
On a single day, on a single day.
On a single day or on multiple days.
It's account, KYC compliant.
KYC compliant account.
The limits are only on withdrawal of the amount.
Limits are only on withdrawal, and my learned friend Mr. Chidambaram was right. Up to 4,000 rupees could in fact be exchanged. By giving 4,000 rupees, you can get 4,000 rupees of new cash, but not in excess of that. The rest of it will get credited to the account, KYC account, and you will be entitled to withdraw it in accordance with whatever be there
Whatever guidelines were
in place at that point of time.
4,000, it was increased to 10,000 from.
And then 25,000, etc., etc.
There was no outer limit insofar as deposit.
Deposit.
No outer limit whatsoever. And that is so even for the NRIs.
But anybody who has money beyond the known sources of income
Right.
should not have deposit.
Yes.
Unlimited deposit.
Yes.
Subject to invitation from the IT department.
But there has been. Millard, there has been. It has been followed up by income tax investigations.
My learned brother adds and ED.
So
I
that's
won't,
why
I'm
they
not commenting. Millard.
deposits in other person's
Yes.
account.
Millard,
They made deposits in
consequence that you will face. So people would, Millard, only go to the bank and deposit such amount as they know that they are holding legitimate. They did. Some people got away with it also, Millard. But not everybody got away with it. The point is, Millard, that in law, all legitimate cash that you had could be exchanged up to 30th December. Guarantee. Beyond that, Millard, we didn't give any guarantee.
All right.
And Millard, the second thing which my learned friend says, eliminate the proviso in that notification,
Yes.
which is dated 30th December. He says that eliminate this proviso in relation to a particular class, namely NRIs who went abroad and left money in India in excess of 25,000. Now, Millard, on what principle of statutory interpretation are we going to read down this proviso to that limited extent? There is no provision, there is no principle of statutory interpretation by which this can be done. He is, Millard, saying that in equity, do it. Because there is such a case.
142, 142.
142, yes, Millard. Millard, I am not opposing your lordship's, Millard, exercise of powers under 142. In fact, each of the special cases which are before your lordship, if your lordship wishes to look at the facts, Millard, and take a decision, Millard, we can have nothing to say about that. So that's the next thing, Millard.
Yesterday you made a statement.
Yes.
That insofar as Mr. Diwan's client is concerned,
Yes.
he had not even made a representation to the
Never.
RBI.
Never, Millard, not within that period. Millard, he came back and tried to, Millard, make an application under 4.2, but that was not received because it was not in the format.
All.
And he could have filed an appeal also if it was within 4.1. Millard, if it is not within 4.1, it is our contention that he could not have made an application. And Millard, I've already, Millard, made those submissions. So therefore, the proviso, Millard, cannot be read down as has been suggested. And the final thing is, Millard, the guardrails, Millard, submission that it is no longer possible to issue diktats. I agree. But guardrails to limit, Millard, the possibilities of economic policy making, Millard. Is that, Millard, part of our basic structure? That's not. And finally, Millard, my learned friend says that it is because your lordships withdrew the jurisdiction under Article 226 and brought all the matters to this honorable court. Therefore, the date should be reopened. Well, I have not followed. 226 would have given him this relief. Your lordship has withdrawn it, so your lordships have the jurisdiction now to give that relief. Milord, the withdrawal is not a reason for suggesting that today there should be a scheme. It doesn't follow from the fact that your lordships withdrew it, because the High Court's powers were there. Now the Supreme Court's powers are there to exercise it. In fact, if anything, he gets a benefit by this withdrawal for two reasons. One, those persons who had come to court were given some kind of an assurance that sections 5, 6 and 7 of the Act will not be applied against them. And the second is that they have got 142. High Court could not have given them that relief. So, my lord, I do not see, my lord, why the your lordship's order withdrawing all matters to this honorable court should be the basis on which a mandamus should now be issued, giving, my lord, directions to have a scheme. My lord, and my lord, I am quite alarmed that my learned friend thinks that there is a huge category of persons who are having a grievance, because that's not evident to us, because the number of complaints is very finite.
All. Yes, attorney wants to say something?
I shall be very brief, Your Lord. And I can't catch up with the speed and sound of my learned. Only wish to 3 points. If the clock had stopped with a notification, we would have all kinds of arguments on the legality, the limits of the notification. How do you read 26, 26.1, 26.2, cessation of liabilities, and so on and so forth? But as it has happened in this case, different from what happened in 46 and 1978, it has happened in 2 stages. The government, on a recommendation received from the RBI, issued a notification. Did not happen in 46 and 1978. And in the ordinance, when it says we want by way of abundant caution, the ordinance says in the preamble, to have clarity and finality on this question, we say also deal with the question of liabilities. Anything said by abundant caution is not wrong. It only tries to clarify the position. You can't pick up an argument from there and say, look at what they're doing, and try to build an argument of interpretation on 26.1 and 26.2. I don't want to get into the question of 26.1 and 26. It's a built-in scheme. Based on 26.1, 26.2 follows. Both are integrally, intrinsically connected. I have the power to say this is legal tender. I have the power to say it will cease to be legal tender. The limitations are built in 26.2. We don't go beyond that at all.
Once it ceases to be a legal tender.
That's right. 34 is for a different purpose. As long as it remains a legal tender, during that period, what is the position of banks, RBI's banks of accounts? That's the only limited operation 34. But 26 is the overarching provision. It is not dwarfed by section 34. As long as 26 does not come into operation, 34 will remain.
Once it ceases to be legal tender, then it ceases to be in the circle.
That's right. Before 26, I said yes, it dwarfs section 34 when 26 is invoked.
Except for the
That's right.
period extended for exchange.
Exactly. It is built into it. I mean, whether you treat it on the basis of contract or not.
After 8th of November, it would be between 2 persons. The transaction will be invalid. It ceases to be a legal tender.
Absolutely.
That would, the liberty is only granted to deposit it in the bank. With the bank, and that's
right.
Compliant.
That's right. But
Mr. Ramani could not have given an amount to Mr. Gupta after that period. Legally.
There's no private transaction.
Private transaction.
No private transaction.
Exactly.
So his argument that even after that, the private transactions could have been done on the...
You have to read it into 26.2 as if a fresh legal principle built into 26.2. I don't think you can do that.
That is what his argument was.
No, he didn't argue.
The second thing is about, I don't want to traverse again,
He could not.
the notification subsequently issued in pursuance of section 4, where the parliament said there can be a grace period. And with the grace period, recognizes certain categories of persons, residents and then non-residents, who will ordinarily carry cash and come back with cash. When my other friend says, no, here is a casus omniscience, right? The parliament the notification omits very important sections of people who go abroad for deriving a benefit of being an NRI. I mean, I wish we preserve the dignity argument to more precious cases. An NRI wishes to go abroad and wish to get a benefit of being an NRI, wish to derive a financial benefit. He doesn't want to lose that financial benefit. He says, oh, don't drop my dignity. I'll have a financial benefit. And you want to get a financial benefit, you are robbing my dignity. I think don't misconceive. There's no dignity involved in it at all. That's why it's important for us to say dignity is operates in an entirely different sphere. Your personal dignity is involved. Your privacy is involved. So when you try to extend this kind of argument, it simply breaks down. The virginity of the argument breaks down. I say there's a limit to that. The last is about the Prime Minister's statement. So when the Prime Minister makes a statement, kindly look just one reading, I keep reading it again and again. Page 27, paragraph 9. I mean, there can't be an argument of estoppel on a statement like this. I wish there's an estoppel against.
That is only an aid for construction, perhaps. The speeches made in the parliament.
That's one way of looking at it. It was at a time when the notification to Section 4 has not come.
Oh.
So that's why the Prime Minister said that maybe someone for some reason, means good reason, a legally acceptable reason, legitimate reason. Therefore, we want to say, I will not forgo my NRI benefit. Should the state step back and say, well, there is a very good reason for that. I should have accepted it. Therefore, it is no ground, no case can be made out on that. And finally, on my 3 point, my argument on paragraph 2.53, a lot of things have been muddled up. I don't wish to give back in the same coin. The argument is after the notification, if the parliament sits back and says, look here is the notification under 26(2). Parliament debates it. Parliament takes note of it. This was the first time I've seen that when a notification is referred to by a parliament, and therefore the parliament, that's why I said very decidedly, the parliament gives a stamp of approval to it. I did not say it's a validating legislation. I understand the difference between validating legislation and the parliament validating it by looking at it. For a considerable thought process gone into parliament, when say I look at the notification, the parliament could have not even, need not have referred to the notification. Need not have. But when the parliament refers to it, you will have to attach some importance to parliament looking at the notification. Will you completely efface it out? My answer would be no. That's about all. Lordship, please.
And Mr. Jaydeep Gupta, we are reserving the judgment number 1. We are granting you time, whoever wants to file written submissions within 2 days. But please pass on the records if you have right now, both of you, if you have the records. Or else by today evening, you can submit the records.
Yeah, I'll put it.
Whatever. It is a perusal of the court.
Certainly.
For the perusal of the court.
Certainly, sir.
If it is readily available, give it now.
I will have it arranged.
Or by evening, you can.
I will have it.
You can give it.
I will.
For our perusal.
Certainly.
If you want, you put it in a
I'll
cover.
put it in a seal.
It's in cover.
I'll do
You can put it, both of you, please give the record, whatever records you have.
Only one small statement. The affidavits are virtually captured to a large extent.
No, let us have the
But,
satisfaction.
no, I'm not saying no. I will be saying that, yes, your lordships may have look into it.
Yes.
And it may aid, probably it may aid.
Yes, yes.
Whatever arguments have been placed
Yes,
for
yes.
your lordships. I certainly do it.
Do it. Thank you so much.
Lordship,
Liko.
lordships in 501.5.
Just 1 second, sir, 1 second. Just 1 second. Mr. Sharma, ML Sharma, what do you want to say?
I want to say only, I want to take 1 minute of the court, only 1 minute, Your Lordship.
Take.
Your Lordship, the entire issue is confined to the decision of the president. That's
All
what
right.
I'm
Don't
telling.
repeat all those things.
I will not, I will not repeat. No, Your Lordship, I will never repeat. That's my undertaking. And that answer AG has not given yet, and they should give.
All right.
I wish to give only 2 citations in response to
Because,
this.
because Article 1110 is much.
All right.
Now he's answering your.
Yes, sir.
The first one is 1975.
With permission, my lord, I am taking only 30 seconds, my lord. My case is this, my lord.
Wait 1 second. Wait second.
1975, 1 SEC.
Sanjeev Naidu.
This is, no, Sanjeev Naidu it comes a little later. 763, 1 SEC 763. Then the next one is 2003, 6 SEC 277. Both are in respect to the Article 77 argument. We made that argument. But as far as 110 argument is concerned, I think it's misconceived. It doesn't warrant a response.
All right.
In my case,
What about the Article Exodus?
All right, sir. All right. We
in
will
my
consider.
case, my lord, applicant father was died due to sudden announcement.
We have understood. We have understood.
In my, I'm taking only 30 seconds, my lord. Applicant father was died due to sudden announcement, my lord. Thereafter, whatever money is received by the LR, they deposit in an account and they are facing the prosecution, my lord. This is the case, my lord. If the announcement is not supporting the law, then we are entitled for compensation, my lord.
All right, sir. All right. Now you're right. Now over. Now you're right. All right.
Lordships, we had submitted that our money was lying deposited in the court before the MM in Rohini. And however, despite several applications filed before the MM, he did not release the money.
Sir, we have told you all these factual aspects will be, have to be decided after we answer these questions. We are not deciding factual aspects. We have been repeatedly telling you.
Lordship.
Over.
On the written submission, I lordship can give time till Monday.
No, sir. We can't give it by Saturday.
All right, sorry.
Heard, judgment reserved, written submissions, if any, on or before Saturday. Date. What is the date? Saturday. Give the date.
10th December.
10th December. Learned Council representing the respondent Union of India and Reserve Bank of India are directed to produce the relevant records.
Your Lordship, I put it in a seal cover. I'm grateful to your Lordships for it.
Thank you so much. You have learned a lot. Very champion is not here. Please convey our.
In fact, Mr. Chidambaram read out some passages from Mr. Rangarajan's book. I told him that I've also read that book. There's something which I can cite. I don't want to trouble your Lordships more with that book.
All right. Thank you so much.